Your new product is ready. You built a website and drafted a launch post. But before you go public, you must check that your product or invention is legally protected to give you rights against anyone who might copy your idea. When business owners and founders create something new, their first instinct is to get it in front of people and build some early buzz. But from a legal perspective, launching without patent protection can be risky. Once your product is in the market, it is no longer a secret, and you might miss the chance to secure a patent at all. A common mistake is thinking, I invented it, so I can protect it later. That is not always true. With patents, timing is critical. Before you launch, pitch, publish, sell, or post about an invention, you need to understand whether anything similar is already out there. That earlier material is called prior art, and it can include patents, articles, websites, or social media posts. Your own launch material can also cause problems. Public disclosure before filing may limit or eliminate your patent options, especially overseas. That is where a patent application, often a provisional application, can help. It secures an early priority date and lets you say patent pending while deciding whether to proceed. Before launching your new product, keep it confidential. Make use of non-disclosure agreements and get advice. A provisional application can be useful when the product is still taking shape. It gives you 12 months to test the market, improve the product, and decide whether a full patent application is worth the cost. But the application only works for what is described. If the invention later changes, any new features may need their own record. And this is just the start. There are other registrations to think about, such as trademarks and designs, which we'll discuss another time. But the point is simple. Don't launch anything until you've considered protection and obtained advice. If you're about to launch a new product, talk to Whitehead Law Group before you go to market. It's much easier to stay one step ahead than to deal with infringement after launch. I'm Peter Whitehead, and this is On the Record.